welcome everybody. Lovely to see you today. Another one of our Data Science Festival Sandbox sessions. As you can see, it's with our good friends from Sheridans, who we've got to know very well over the last 6 months. In terms of today, we're very lucky to have Stefano with us, who's going to be talking about data privacy, AI regulation and beyond, legal essentials for data scientists. It turns out us data folk are very keen to know the law. It's proved to be a very popular session, and I think in the current climate, something that we should all be aware of. So I'm very thankful to Sheridans and also to Stefano for giving up their time to come and share with us. In terms of that, Stefano, I'll maybe ask you to turn your camera and your microphone on now, if you don't mind. Come and join me on stage. How are you doing,
Thanks.
sir? Good to see you.
You too. Yeah, not too bad. Thanks. And hi to everyone in the audience.
Mate, we are lucky to have you, man. We're lucky to have you. Stefano is a partner in the data and technology team at Sheridans, who are a leading London law firm. Really nice mix in Stefano's background, actually, across tech and law. But obviously, I'll leave Stefano to dive into a bit more details once he starts to talk. In terms of that, I do just want to give Sheridans a massive shout out. Actually, we first started talking to Stefano last summer. It was him that came to us and was kind of like, you know, as a community, I think there's an opportunity here. I think we've got some really good content we can share with the community. It's a relevant conversation. They came and joined us at Oktoberfest. So any of you that were with us in October, Stefano possibly bought you a beer. They sponsored the Oktoberfest bar, and they provided us all with some fantastic branded Oktoberfest pint glasses. So I, for one, have definitely had a beer on Stefano. So if you've had a beer on Stefano, feel free to put a comment in the chat and say thank you. In terms of today's session, though, there's a lot to it, but we're definitely looking for it to be interactive. We have some resources that Stefano's pulled together, which we're going to send to everybody afterwards. But in terms of the format, we're going to go for roughly 20 minutes of content, then break for some questions. There'll be another 20 minutes of content and finish with some questions at the end. And the one ask I do have is, if you are asking a question, there is a Q&A feature within the Zoom software. Please put your question into the Q&A feature. Use the chat to, you know, say hello to each other. Let us know you're watching along, which is always nice. If you do that, you have to flick the box to message everyone rather than just message us. But in terms of that, Stefano, I will stop sharing and we will get you set up to get going. So if you'd like to share your screen, we'll be good to go. Did anyone join us at Oktoberfest? Has Stefano bought anyone a beer? Give us a little beer emoji. There must be someone. It'll just be me in the chat with loads of beer emojis. Amazing, mate. That looks all good stuff. So yeah, you're very good to go, Stefano. I will hide myself now, but I'll be back for the Q&A and enjoy the session, everyone.
Thanks very much, David, and hi everyone. Yeah, as David said, I'm a partner at Sheridans in our data and tech team. So I'm a lawyer, and my background is in computer science. It was a long time ago now. I qualified as a lawyer 10 or 11 years ago, but before that did a bit of software development. So I've naturally fallen into advising on tech and tech businesses. Today we're going to be talking about some legal issues that hopefully will be relevant to a lot of the people in the audience. So looking at data science, but focusing on AI really. I'll touch on a few different subjects. A couple of other details are mentioned in the handout that you should get afterwards that David mentioned. I will be writing a bit of code, or at least trying to write some code, because I thought that listening to a lawyer talk for an hour can get pretty dull, I should know. So I thought I'd try and make it a bit more interesting. So the idea I've got is to actually, during the presentation, we might build something and talk about the legal issues that crop up as we go through, which hopefully will make it a bit more practical. Please do drop any questions in the chat, and we'll break, as David said, to pick some of those up. And obviously, if there's anything you want to talk about in a bit more detail, you should get my contact details. So drop me a line afterwards, and more than happy to talk that through. So to frame the start of the presentation, I'm going to pretend I'm a lawyer. Well, I'm not going to pretend I'm a lawyer. I am a lawyer, but I'm going to pretend that I am building a chatbot, a sort of expert chatbot, with the aim of explaining something about the law to my users. So it's the kind of thing that you might see on a a website or some sort of chatbot service. I'm going to build a little chatbot to advise people about cookies. So bear with me, I'll just switch into VS Code here. Now, I'm not a professional software developer, so apologies if my code isn't the tidiest. I won't spend a lot of time doing this, but just to illustrate some of the issues that come up. So I've assumed some technical knowledge in the audience, but it doesn't matter if you can't read my code. Mine isn't very good anyway, but I'll explain what I'm doing as I go through. It's just a way of illustrating how and when legal issues come up, which hopefully will make it a bit more useful for you in practice. Okay, so what I'm doing here is just importing the OpenAI API library and a couple of others, and I'm going to use those to build my chatbot. I'm not going to bother handwriting all of this. Here is some code I wrote earlier. So what I'm doing is putting together a little bot, and the idea is that it's going to be useful to teach people about cookies and the law. If we quickly run this. So what this is doing is it's connecting to the OpenAI API, and I'm just going to send it some questions. Why do people love cookies? So it's telling us people love cookies for various reasons. What this done is it's sent the query to ChatGPT, and that's sent back some information about cookies being delicious. Now, before we even get to this, there are already some legal issues we should have considered by this point. In fact, the very first line of this code here raises a legal issue. These imports, what they're doing is importing libraries. I've not written that code. It's written by someone else. Who's to say that I can use it? Just because it's publicly available doesn't mean I'm entitled to it. So we've got the OpenAI client library there, along with a couple of others. The point is that when you're relying on third-party code, you need to understand what licenses apply. You might need to pay to use this software in a commercial product. It might be open source, in which case you might be free to go ahead, or you might be required to release your own code as open source if you use it. There are a whole range of different licenses with different teeth. Some of them require you to release your source code, even if you're not distributing your applications. But let's say I've done some digging. I've made sure that I'm allowed to use that software. I've got this basic chatbot here, and I can ask it questions. It'll give me answers. As we've seen, the bot likes cookies. Who doesn't? But as a lawyer, clearly I'm talking about something slightly different. I want my chatbot to help people understand the legal rules around cookies. So I need to give it that detail. So what I'm going to do is I'm going to go and find some expertise about cookies that I can use to educate it. So there's a website, data.protection.law. Sounds like a reasonable source for this kind of information. Let's see what it has to say. That's just going to load there. What I'm going to do is find a source of expert information and use that as the context for my chatbot. So this looks like it's pretty spot on. Cookies, analytics regulation. That sounds like the kind of information I'm looking for. I'm just going to borrow that. Let's see what this article is about. taking a bit of a while to load. So this is a blog article telling me a little bit about analytics, what cookies do, how to find them, what regulations got to do with it. Let's give my bot this as additional context. At the moment, context is blank. Let's give it this. So what I'm doing here effectively is instructing the bot to go and fetch this blog article and use it as context. So effectively scraping that website. And let's see what difference that makes. So now if I fire up the bot and I ask it about cookies, what do I need to, sorry about my typing there, know about cookies? Hopefully, there we go. So now it's talking about regulations, the GDPR, e-privacy, and bits and pieces. That's a lot more useful. So there's something else I need to think about here from a legal perspective. That's copyright in the source material. We've built what is effectively a very simple retrieval augmented generation RAG bot here, and it's using this blog article, but I don't know if I've got rights to use that. I've just scraped this website and used its content in my bot, and the author may not be very happy about me doing that. So I need to think about the underlying software, for example, the libraries that I've imported, along with anything my chatbot's using for its context and expertise. They're both protected by copyright, which means I need a license to use them. Let's go back to the slides here. So IP is relevant in a range of ways when we're talking about AI. You've got the code, which will be protected by copyright. You'll run across things like open source software, third-party libraries, possibly IP and AI models being asserted. Then you've got the material the model is using to give its answers. So the cookies article that I just used there. But before I gave it the cookies article, it already knew something about other cookies. And that's because it was previously trained on materials that were relevant. So it already had some background information. It was about baked goods rather than the kind of cookies I'm talking about. But there's that training data that's also protected by copyright in the case of the material we're looking at there. Now, this is a relatively tricky issue. There are government consultations going on at the moment to decide whether the law should give developers more freedom to use public data to train models. At the same time, there are lawsuits underway going through the courts, which are looking at whether you need a license to train those models. So the law isn't standing still. Fundamentally, right now, if you train a model to, let's say, create art in the style of a particular artist by feeding it their earlier work, then do you need a license to do that, to train the model? The answer probably yes. That begs the question, so how do we work around that? How are people training their models? Lots of different approaches, but there are large organizations these days who are striking deals with major platforms to license content for training. I think Reddit may have been one of those recently. Others are hiring teams of freelance workers to generate training data, workers and experts. Some are telling their users that in exchange for access to a platform, users grant them rights to use their content for training and that kind of thing. So a range of different approaches going on, but something important to think about. So you then have the input data, the queries that I'm putting into the bot or into these systems. Generally, you'd expect users to own that. They may well also expect to own the output data that's coming out of the model if you'll let them and if you have the rights to do that. And you also have the weights, the parameters of the models themselves. I've not really focused on that too much today. Happy to talk about it, but it can be a tricky area and there may well not actually be any real IP in models that's protectable in a traditional sense. So that's IP. Let's go back to the cookie bot. Now, after all that, maybe I'm more interested in edible cookies than electronic cookies. Let's say I'm now an app developer and I want to share my passion for cookies with others. So I'm going to turn my chatbot into a helpful recipe assistant. You tell it what to make and it'll give you a recipe. I'm just going to tweak this. That's a slightly different context. Now, if I rerun this, what's a great cookie recipe? And now it's going to hopefully give me a great recipe for a cookie. Yeah, there we go. That looks delicious. So it knows some stuff about cookies, but I want it to be more innovative. I want to, let's say I want to bring it really up to date. That means I'm going to need some expertise. Where am I going to get some legitimate training or RAG data for that? I'm not a cook. I need to find an expert. So what I might do is, let's say, invite some job applications for a baking consultant who can come and help me train up my bot. I imagine there'd be a lot of interest in that. Let's say theoretically I've done that, and here we go. Got some job applications flooding in. Liam's an expert in gluten-free and vegan baking. Olivia, bread fermentation and heritage grains. There's a lot of applications here. That's going to be a lot for me to sift through. Surely AI can help me with this a little bit. I wonder what I can do. Let's say I use my bot to help me out with this. So what I'm going to do is I'm going to point the bot at that list of job applicants there. Tweak this prompt. Okay, so what I'm doing now effectively is tweaking the bot so that it's looking at the job applications that I've got in that I want to sift through. And let's run that now. Who should I hire to help me train a baking recipe bot? So I'll skip that. Okay, quick response. Would have taken me ages to read through all of that. The bot is saying I should consider hiring Matthew Baker because he specializes in pastry education and training. Sounds about right. So amazing. It saved me a lot of time. I've got a short list here of a couple of people to consider. So I can go and pick someone and that's going to help. So I can go and use that to speed up my process. Or can I? So under the EU AI Act, different types of AI system are categorized according to their risk level. So there are types of AI system that are actually prohibited. The risk is unacceptable. For example, systems that are using manipulative techniques, social scoring, real-time public biometric identification. Got some examples here. Predicting crime, so sort of a Minority Report style thing. These are deemed unacceptable risk. It's a bit of a summary here. There's some nuance to it. And then you also have high-risk systems. So high-risk systems include, again, some biometric systems and other AI systems that maybe have an impact on education, employment, or access to essential services, and some other examples. Now, the bot that I've just used to sift my job applications is likely to be a high-risk system. It's automatically filtering CVs and deciding who's getting access to me as a prospective employer, and therefore it's likely to fall within the high-risk category. And that means that I may have some more intense obligations under the EU AI Act. So you have to have one eye on what's the actual nature of the system you're building, and does that attract any regulatory implications? Now, not all of these rules under the EU AI Act are immediately applicable. Some of them will be coming in a phased approach For example, August next year, some of this stuff will kick in. Now, aside from the risk classification of the system, we also need to think about what our role is in relation to the system. With the cookie bot, I was building something that I might offer to others. Come and use my cookie bot. It'll give you some great recipes. With the sifting that I've just done there, I was using the tool myself. I was deploying the tool to help me sift job applications. So in the context of the EU AI Act, what these are different types of operators. Now, different operators have different obligations. As the provider of the system, supplying it to others to use with a cookie bot, for example, I've got one set of obligations. But as a deployer using this to sift job applications, I have different obligations. So if I was, let's switch to the next slide. If I was a provider, my obligations might include this kind of thing here. So I need to ensure that people know they're interacting with AI and they don't think that they're just on the line to one of my baking consultants, for example. I need to ensure that the output is recognizable as synthetic. Less of an issue with the cookie bot here, but let's say it was outputting visual aids, so pictures, for example, to explain how to do it. We might need to label those in a machine readable way to ensure that they're recognizable as Gen AI. And if it's a high risk system, which unlikely to be the case when it comes to cookies, but if it were, then, for example, if I was providing the job sifting tool to another employer, then that I may be then providing a high risk tool, and I'd need to assess and manage bias and other risks. Ensure that it's designed with these safeguards in mind. Make sure that there's a way to log usage and allow for some human oversight. I'd need to give the people deploying my tool instructions and prepare some technical documentation. And there are a range of other regulatory hurdles where you may need to register with the authorities. There's conformity assessment and other bits and pieces like that. So you can see that if your system ends up being high risk, then there is more to think about. So that's if I'm providing it. If I'm using it as the user effectively of the system, if I'm deploying the CB tool, my obligations might be slightly different. So if I've got staff using the tool, I need to make sure they know how it works, ensure that my staff are AI literate. That actually isn't just a deployer obligation, that also would apply in the context of providers. Again, if I use the tool and it generated some creative works, generated some images, I may be required to label that content as AI generated if I'm using it so people know that it is it's synthetic. If I'm using it in a high risk situation, which again may be the case with the application sifting tool, I might need to keep logs, ensure there's some human oversight. It's not an entirely automated process, which could involve some risks. I need to follow the instructions that the provider of the tool has given me, and I may also need to monitor for incidents and risks and report those. So those are two categories of operator and some of the obligations that are relevant under the EU AI Act. Now back to the recipe bot. I've created a chat bot. I'm putting it out there for people to use. So I'm providing the system, and presumably then my users are the ones deploying it. The customers are the ones deploying it. Now that doesn't mean that all your home chefs now need to think about the EU AI Act whenever they're baking cookies for their neighbors. There are exceptions where, for example, you're deploying an AI system for a purely personal, non-professional purposes. So your average consumer probably doesn't need to worry about complying with the EU AI Act, which is only fair. But if I am selling the app or as a service to consumers, I'm probably going to need to think about consumer protection law. So there are a lot of rules which matter when I'm supplying an AI system to consumers. Just a few considerations I've flagged up here. I need to let people know who I am, provide information about the service and pricing, along with details of their consumer rights. So consumers have a range of rights. when it comes to buying goods and services, including rights to cancel, to change their mind in relation to subscriptions. And they also have rights if something goes wrong. I need to ensure that my terms and conditions with consumers are fair, and they are also entitled to compensation in certain circumstances. I can't just, for example, bury some nasty terms and conditions in the small print and say I have no liability for anything. There are limits to how I can use a contract and my terms and conditions to avoid liability. Now, let's say I've had some success and users love the app, obviously, and I'm getting some great feedback. Okay, let's say here we go, found a review site. People love Steph's Cookies, my new app. Most of these look pretty positive. Some of them not great. Now, let's say I want to use some of this to promote the app, but I don't necessarily want to publish all of this stuff. So even before the advent of ChatGPT, a key focus of machine learning has been classification. So putting things into categories. Is something a picture of a dog or a cat? We'll come back to that a bit later. Is this a big number or a small number? Is this something positive or negative? So maybe I can use AI to help me here, pick what I'm going to use for my marketing. So let's see if I go back to my bot here. And what I'm going to do is, rather than pointing the bot at the CVs, I'm going to point it at the reviews. Now I should be able to ask it to help me here. Let's say, give me the top 5 reviews of my app. Let's see if that works. So again, it's scraping those reviews, passing them through the GPT, and it's popped out and it said, okay, here we go, 5 5-star reviews. Excellent. Again, save me loads of time. Let's whack these on the website and use them for promotional purposes. Now, not so fast. Advertising regulation and consumer protection law actually go beyond just managing my relationship with my customers. And they include a range of rules to protect consumers from what you might consider perhaps less savory practices or activities which might be unfair or misleading. So if I use AI to automatically cherry pick the best reviews here, and I only publish those on my website, that's likely to be considered unfair, and I may well breach the recent UK Digital Markets Competition and Consumers legislation. The consumer law sets out rules for a range of things, including making sure the way reviews are presented is honest and transparent and not misleading and that kind of thing. So aside from just managing the relationship with my customers, there are wider things to think about when it comes to consumer protection law. I wonder if that might be a good time to pause for some questions before I carry on.
That would seem a perfect time to pause for some questions, Stefano. First of all, who doesn't want their legal partner to be able to write code? So two thumbs up for that. That's got to drive business. In terms of that, absolutely fascinating. We've got 5 questions in the Q&A. If you have any more questions, please stick them in there now. The other thing I will call out, you can, if you haven't got your own question, also upvote other people's questions. So if someone else has asked a question you think is particularly interesting, you can give it a little thumbs up and that'll go to the top. In terms of that, Stefano, if you open the Q&A feature, and perhaps if you rank, instead of most recent, do most upvotes, we'll maybe fire through it in that order and see where we go. In terms of that, I've got a couple of questions myself as well. I'm the host. I'm going to start with one of my own. Stefano, apologies to everyone watching along at home. Right. But in terms of that, I guess the first question that I had was, other than inputs, outputs, training data, is the model itself IP?
Interesting. So it's an important question and a tricky one. Um, Obviously, huge resources go into training models, so people rightly want to know, can we find a way to ensure we own them? I think so. What we're probably talking about here specifically are the weights, the parameters that make up a model. I don't think we've necessarily got a great answer for this legally. So if we think about different IP rights, you've got copyright protects the blog article that I mentioned earlier, um, and things like the code you write. So copyright protects expression. Um, Authors use their intellect to express an idea. That could be a book, a song, painting, that kind of thing. These are all protected by copyright, but it doesn't fit a model very well because weights in a model aren't the intellectual creation of an author. They're not authored, they're fine-tuned by an algorithm. You could theoretically consider patent protection. Patents, in a way, protect ideas or processes. I think that, again, has some challenges. I'm not sure how you'd necessarily go about doing that in a way that was useful or successful. Um, Obviously, models won't be protected necessarily as designs or trademarks. There is a database right in the EU and the UK, which could theoretically offer some protection, but it's quite limited. Only offers protection if you're a UK or EU business. But what it does is it protects the investment you make in arranging data into a database. Now, even that, I don't think is necessarily a great fit for IP protection of a model because um, what it's aimed at protecting is the investment in arranging data into a database, obtaining all of that data. Whereas when we're talking about training a model, you might spend resources creating the weights of the model, but actually database rights don't protect the investment you make in creating the contents of the database. The more the work you put in gathering together the data and organizing it. Um, Model weights they're not on all fours with, a database that you query to extract information. So I suppose what I'm getting at is it's not clear that IP really protects models, and it may be that confidentiality, keeping it secret, is perhaps the primary way to try and protect them. Sorry, that was quite a long-winded explanation.
No, I mean, it's quite clear actually. This is a deep subject, and it feels like we could talk for the afternoon on it. So I really appreciate you driving the conversation actually. I think that leads into actually there's a couple of great questions from Gemma, but one of them actually, Gemma, I potentially almost I feel like Stefano's answered that question actually. Interesting about weights being potentially protected. What about overall model architecture? So I think we'll class that one as covered in his answer, Stefano's answer there. But we will take another question from Gemma that has been upvoted and is towards the top there. I guess following on from that, Gemma's talking about how can we ever know what data LLMs are trained on, and what copyright applies to these. You mentioned that currently work is being done on improving these laws. What about if you create something now using a model and in the future it is deemed that the model uses data that was copyrighted? Where does that put you as the user of the model? So I guess in general, can you talk a little bit around the data
Yeah,
that's being used, and go on from there, please.
yeah, that makes perfect sense. And yeah, a very interesting question and forward-looking. So, um, first part of the question, how do we know what data they're trained on and what copyright applies to these? Well, the law is actually now, as it's developing, will soon oblige the developers of certain AI models to publicly explain what content they've used to train it and to explain how have we gone about making sure copyright's respected in doing that. So the law is moving in the right direction if you're looking for transparency. Those obligations haven't kicked in yet, but they will, I think, August next year. Um, don't quote me on that. It might be the year after. Now, in terms of what's going to happen if you create something now with a model, and then later on it turns out that model uses copyright material and its training data. So you've got a few different things here. You've got the training data protected by copyright, goes into the model. Does the model then infringe copyright? And if it does the output that you're using infringe copyright? They're actually separate questions, really, but it depends on really the answer to the question depends on what the output is and how you're using the model. So let's say in the first case, you start using a model as a component in your system. So in the same way that I'm using the chat API from OpenAI there. Now, if I am continuing to use, if I'm offering a service that relies on an infringing model and I'm using that model and I'm not entitled to, there could theoretically be an issue there. If on the other hand you use a model now, it produces some output. Let's say you use it to create an image, and you've got the output content and image, and it later transpires, okay, it turns out that that model or use of it was infringing. I don't think that's necessarily too much of a problem for you unless the output that you want to use into the future does reproduce, is a copy of some of the copyright data that was used to train the model, if you see what I mean. So if you use, let's say the law moves in the direction that you use some infringing data to train a model, and that turns out to be IP infringement, but you've used that model to create some new information. And if that new information that you produced isn't actually a copy of what was in the original training data, that doesn't mean that what you've got now is an infringing copy, because it can't be unless it substantially reproduces what went into the infringing model in the first place. So you're probably on reasonable ground there. But it's a yeah. I mean, you highlight a very real risk, which is that these models are not deterministic. Some of them have been shown to memorize their inputs, and we know that some models that are in wide use can output a copy of something, or very close to a copy of something that was used in the training data that you don't have rights to. If you then use that data, use that output yourself, you may well be infringing the rights of the original author or artist.
Yeah.
Does that answer the question?
Oh man, yeah. But equally, again, I feel like we can talk and talk. So yeah, for sure. I guess jumping down. So the question there from Rosemary about your background. We'll maybe save that for the very end. If we have time at the very end, we'll perhaps talk about your path in terms of your career. But the question there from Rosemary: Are you for or against the topic of debate for AI copyright consultation? I guess that question is talking about AI creating the content, AI content, AI generated content and copyright. What does that look like? Or have I read that wrong?
I'm not sure, Rosemary. I might have this wrong, but I suspect you're talking about the consultation the government's carrying out to decide whether or not we should allow people to make freer use of data that they find for training models. They call it text and data mining exceptions that the government's consulting on. Am I for or against it? I think it's very tricky. I think, so for context, at the moment, the UK, for example, has an exemption that allows you to, under certain circumstances, go and find some material that you want to use to train a model and use that. But it's quite limited. So it's really for research, and it's not for commercial purposes. So it wouldn't help me if I was using it to train my cookie bot or anything like that. Widening the scope of that, I think, is it's clearly a problem for the artists and the authors of the work that's being used without their permission, and so we need to be careful about that. But I don't think that means that there isn't a world where we can ensure that people have access to that for training, but not in a way that disadvantages the people that have put their time and effort and their skill into creating that material in the first place. I think that there will be a way of doing that, but it's a tricky balance to strike. I know that I'm sort of on the fence there, I suppose.
Okay, amazing.
I'd love to see it. I'd love to see that happen, and because I think it would open up a world of opportunity. But you can't do it at the expense of other people without compensating them.
Makes sense.
Quite frankly, so we have traditional methods for but dealing with collective management of compensation, for music, with PRS and that kind of thing. I'm not saying that's the right model for something like this, but there are controls you can put in place, opt-out mechanisms, use something like a robots.txt to say, no, you can't scrape this. Have some parameters around compensation and how material can be used. It's complicated.
Yeah, mate, for sure, for sure. I'm a little conscious of time. We're 20 to
Oh
2
yes.
UK time. There's another 6 fantastic questions already there, so we could spend the rest of the session doing that. But I'm wondering if it's perhaps best to jump into the second half of the presentation, and then we'll blast through as many of these as possible at the end. Does that make sense?
Yeah, that sounds good to me.
Yeah.
I'll try and rush through this a little bit so there's a bit more time at the end.
Yeah,
So yeah,
I can
let's go
already
for it.
tell we need to get you back, Stefano. Well, maybe just come back and do an Ask Me Anything and just literally do an hour of questions. But mate, if you're happy, I'll disappear again now, and then we'll pick up the questions from there.
Sounds good. Okay. I think my screen's probably still showing, isn't it?
It is. Yes, you're looking good.
Okay. Okay, great. Close the Q&A. There we go. Okay, so through honest marketing, I've used those reviews and I've hit the big time on the app stores. But let's say I want to branch out and I've got my cookie bot. Some professional bakers out there might want to use my cutting edge tech that I've developed this afternoon. If I'm selling this professionally rather than to consumers, I've got more freedom to decide what's in the contract. But my customers are also going to be more sophisticated and they'll want some reassurances to help them manage the legal risks, some of the legal risks we've just been chatting about in the Q&A. So if I'm negotiating contracts to supply my cutting edge baking AI tech, what are some of the issues that I need to think about? I'm just going to talk through a few of them. So liability, I'll want to agree with my customers some reasonable parameters around who's liable for what, along with some overall limits of liability. We're talking about AI, so the output from the system may well not be deterministic, and I'll normally want to disclaim my liability for the output or reliance on it by my customers, unless I've got some confidence in what the output's going to look like. It might be that I've grounded the models that I'm using and the systems I'm using, and I know that I can trust the output, but if I can't, I'll normally want to disclaim responsibility. So for example, if a baker uses my platform and it tells them to start baking cookies with fish-based cookies and their business tanks as a result of it, I'm not saying that wouldn't be nice, they might be nice, but I don't want to be responsible for their business losses in those circumstances. Next, ownership of IP. We've spoken about this a little bit. It's often quite straightforward. Generally, you'll have some existing IP. There'll be some input from the customer. Then there'll be the output. Customers will own their inputs. They'll want to own the output, and that might be reasonable, but it isn't always. So let's take the example I've got here. Sometimes the output is a combination of inputs, the IP of the platform provider, output from the AI model, and maybe some RAG data that could come from a third party. So it might be that I plug my app into a third party recipe database, and it does some clever stuff. Tells the users, what's a good example? Let's say somebody says, I'm catering for a wedding. Some people are vegan, some people are gluten free. Give me a menu of baked goods. It may then pull some recipes from another site, combine those with some of the expertise that my baking consultants have put together, and output a mishmash. Now, in that situation, you may not have the rights to license or assign all of the output to your users to do whatever they want with. So hopefully that's a good example of how that works and why you need to think about it a little bit more carefully sometimes. Service levels, customers will normally want an SLA. That's not normally too much of a problem. I might be able to offer some firm guarantees about how long my models take to give a result. I might be able to build in some resilience, give some uptime guarantees, that kind of thing. If I'm dependent on a third-party AI supplier, so here I'm relying on the ChatGPT API being open, I might want to try and exclude responsibility if that goes down, where it's not really my fault, it's a third party. And you may say, well, some sophisticated customers may say, well, it is your fault because you should have built in redundancy, and perhaps they're right. But some of the questions that will come up that you need to consider. Confidentiality. So customers will generally want their data to stay confidential, and for it to only be used to provide the services to them. On the other hand, I might actually want to do something with their data. So for example, I might want to monitor the way they interact with my tool, use some analytics, try and understand what people are doing with my recipe bot and use that to improve it. I might also want to moderate inputs. So take those inputs, carry out some moderation to make sure that people are staying safe while using the product. And I might want to use some of their inputs or some of the outputs for training data. So these are all issues that you need to carefully think through when you're negotiating contracts. Subcontracting is an often overlooked part of the process, but it's relevant here because, again, in my example, I was using the third-party API. Customers will often impose a slew of obligations on you to do with things like availability, but security, audits, data protection, rights to control how you deliver various services. Sometimes even they may expect to have a right to vet your personnel or influence who's working on the project. Now, you might be happy to offer that control if you're supplying the service, but it's quite common for particularly large customers to expect those obligations to flow down into the supply chain. And that can cause a problem which is sometimes overlooked. But if you're subcontracting to a third-party AI supplier, I'm going to struggle to get OpenAI, for example, to agree to all of the audit rights or all of the other expectations that my customers have for me. So there's often some discussion around how you can reach a compromise or at least understand the risk when that kind of thing crops up. Transparency. So businesses are increasingly interested in understanding what's sort of inside the black box. They may want access to your code. They may want access to your models, guarantees around explainability. It all gets quite context specific, but it's really just a case of sort of striking a balance between what's possible and what's important, and negotiating to find a reasonable middle ground. That's something that I've noticed has come up increasingly. And compliance, there will be some discussion about various compliance issues. We've spoken about the EU AI Act, but there are obviously a host of other compliance obligations that might come in. So we've spoken about the EU AI Act, consumer protection. There's also the Digital Services Act. If you work with financial institutions, there will be the Digital Operational Resilience Act. In the UK, the Online Safety Act and Ofcom codes of practice are starting to kick in. There are platform to business regulations and, of course, the GDPR. So whether you're selling data science to businesses or customers or giving users a way to share or find data or content, or you're just part of the supply chain, there will generally be rules that you need to follow. And I find that we spend a lot of our time in my team figuring out which rules are relevant to different clients based on their business models and their activities. So there's no time to touch on everything. I've mentioned consumer protection, the EU AI Act, IP we've spoken about. Data protection is another generally pervasive issue. Let's have a quick look at that. Just going to go back here. Now, let's changing lanes a little bit. This is my dog Sprocket. I think he's pretty cute, but he's got imposter syndrome. He doesn't think he's got what it takes. Doesn't believe me when I tell him he deserves a treat. What if I could build an AI app people can use to reassure their dogs and make them feel better? So I'm not going to code this from scratch here. Here is some code I wrote earlier. Okay, so now I'm just going to upload that picture of Sprocket the dog, and see what the bot says. Now, what this is doing is it's taking the image, serializing it, just uploading it effectively to OpenAI and asking it about the dog and whether it deserves a treat. It's come back and it said, yep, it's a lucky day, give the pup a treat. So that has processed a photo of Sprocket and given us a response there. Now, Sprocket is a dog. He's not human. Unfortunately for Sprocket, that means he doesn't have rights under the GDPR. You need to be both human and alive for that. However, let's say if Sprocket did have rights like us, then what this app here is doing is it is collecting personal data. That's the photo of Sprocket, and it's sharing it with a third-party API supplier, and it's no treats this time, and it's giving us a response. So it's collecting personal data. That means that I need to consider the GDPR. So what does that mean? I'm conscious of time, so I will run through this relatively quickly, but it means that you need a legal basis to process the personal data. So there are a few options. This is a legal justification for using personal data in the first place. I might rely on consent. I'm not sure Sprocket is necessarily going to be able to give me consent. If he was using the app himself. So if a user is using my app, then I might be able to rely on performance of contract. So my user is asking me to do something. I've contractually agreed to perform a service for them, and I need to handle their photograph to provide the service that I'm offering. Alternatively, I might have a legitimate interest in processing the photos that I'm using to provide this app. So you need a legal basis, and there are various compliance obligations that attach to each of those. Drop me a line if you'd like to talk about that, because it's one of my favorite subjects. I'm not going to dwell on it now, given the time we've got. But a couple of other GDPR considerations. Transparency. I need to explain what I'm doing with data. So I need to be explaining what I'm doing with data, why I'm doing it, what my legal basis is, explain what Sprocket's rights are, what he can do if he's got a complaint. This is the kind of stuff that you find in a privacy policy effectively. So I need to do that. I'm also using a third-party API here. That means that OpenAI is my sub-processor under the GDPR. To comply with my obligations there, I need to have a contract in place with them as my processor, and that has to include a number of specific clauses. This is something suppliers generally deal with in their standard terms of business, but you do need to check. Now, there are a range of other obligations to consider under the GDPR. I'm just going to look at two more here. Firstly, international transfers. Depending on how my API supplier is set up, they may be abroad, so I might be sending Sprocket's photo to servers internationally. When you're doing that, you need to bear in mind that the GDPR restricts international transfers of personal data, and that means there are a few hoops to jump through. You may need to sign special clauses. You may need to carry out risk assessments. And this is an area actually where UK and EU law differ in some respects, so it can be quite complicated. Some countries you're able to receive the data, but only if you've gone through a certification process, like in the US. But I won't dwell on that. Drop me a line if you want to talk about that anymore. One thing I do want to finally touch on is, so it said today, no treats. Previously, it said yes to treats. The GDPR gives people the right not to be subject to automated decisions if those decisions have a legal impact or similarly significant effect. So I know for sure that Sprocket will think he's definitely going to consider this decision as to whether or not he gets a treat to be legally significant. That means that to comply with the GDPR, we probably need to have some form of human moderation before he actually misses out on the treats he deserves. So I'm going to leave it there. Drop me a line if you've got any other questions and want to cover that or any of the topics in more detail. I suppose in a roundabout way today, we've spoken about IP, data protection, consumer law, the EU AI Act, considerations when you're entering contracts. We've looked at a basic chatbot. We've done some RAG. We've done some multimodal automated decision making, some high risk employment related sifting, some sentiment analysis, and looked at some of the legal issues arising with each. So hopefully there was something in there for everyone. But yeah, let me know if you've got any questions.
I feel like you've absolutely smashed that, Stefano. We have to check if Stefano's an AI. I can see there's some clapping emojis on the screen, but I need them in the chat. Before we're going to fire through a couple of more rapid fire questions, but we will try to keep it to that 1 to 2 o'clock UK time. I know people are joining from elsewhere, but we've got about 4 minutes left. I would love some little comments in the chat. It's always nice to give a few shout outs. Let the speaker know that people have been following along at home. What I might also do, Stefano, if it's okay with you, I might get you to stop sharing your screen. People will be able to see our
Yep.
faces a little bit bigger for the last couple of minutes. Sprocket, great name for a dog, very good looking. So definitely deserves a treat. We love that. I will fire through a couple of these comments. In terms of the questions, I do feel like there's more in this, Stefano. I need to talk to you afterwards. Like we could have gone longer, or we could have made this a two-parter. But in terms of some shout outs, Charlie, amazing. Charlie's had to drop off. Thank you so much for creating so many questions. Looking forward to watching the rest of the video. Louise, a great part of the community. Again, I need to disappear, but thank you, Stefano. That was a really good talk. Gemma, really enjoyed the format of this talk. Thank you. Where are we, fella? Clapping emoji. Love these sessions. Thank you. Thank you, Stefano. Brilliant presentation and good to see you can code. Like, everyone's impressed with a bit of live code, man. It always goes down well. And I'll let you in on a secret. I had no idea Stefano was going to do that. So that was a very pleasant surprise. Dr. Maria, thank you so much for your insights. Rose, thank you. That was brilliant, very thought-provoking, informative. Really enjoyed this session. Stefano presented a very engaging way. Amazing breadth of topic, very informative, engaging, and the cute dog. So the dog's getting some shout outs. And then finally from Ian, thank you so much for making it so technically relevant with live coding. So that was, mate, absolutely awesome. I'm going to go rapid fire. We're going to do 2 questions and then we will draw things to a close. I think one thing I always think about is a lot of content now out on the internet. A lot of it is being scraped. There's potentially people out there in the audience that are scraping data to ingest into their models and stuff like that. And I just wondered what the legal basis under GDPR, what's the legal basis under GDPR if you are scraping data from the web to train a model? What does that look like?
Yeah, great question. And it's a tricky one. Again, could talk about this for quite some time. If I'm scraping a website, some of the data is personal data, then I need a legal basis. As I mentioned, there are a few options for that, things like consent, but I can't rely on consent because I don't have a relationship with the people whose data is on the website. They don't know who I am. I can't rely on the performance of a contract with them because I don't have a contract with them. There are a few other options to consider, but given time, just to sum it up, effectively, legitimate interest is probably the only available option unless you have a relationship with them. So, if it's your platform and you're collecting data from your users, there may be another way of doing it. But if you're scraping from a third-party site, legitimate interest is probably the only available option. And that's a problem in a lot of cases, because to rely on legitimate interest, you have to balance your interests against the impact on the people whose data is being scraped. And in a lot of cases, they won't know it's happening. They're losing control of their personal data. It's invisible to them, and you may be breaching IP in some way, which again can have an impact on whether or not what you're doing is fair and lawful, and that can limit what you're able to do with it. So the long and the short of it is, it's tricky. If personal data is scraped and used for model training, you might struggle to legally justify it under the GDPR.
Great. Thank you so much. I think to draw things towards a close, there are more questions. I need to think what we're going to do with these questions. It may be, Stefano, that we can take these and turn them into a little blog post, and perhaps we've got them all. We can follow up with them afterwards. But I think in terms of that, the drawing things to a close, I definitely want to thank you and Sheridans for being so proactive in this conversation. I think it's clearly more and more things that data professionals have to think about. I think clearly from the questions, from the interest in the session, more and more people are becoming aware that actually we need to be thinking about this. So thank you for that. Thank you massively to Sheridans. I know also you've been very good at saying connect with me after, follow up. So if anyone needs any legal advice, follow-on conversations, please, Stefano and Sheridans are the right people to be talking to. I guess in terms of wider resources, just as I say, wrapping things up, if people are sort of dipping their toes, starting to read about this, I know we're going to send them a sort of top 10 things to think about. Are there any other resources on your website or any other books, reading points that you recommend for people to perhaps keep the conversation going? I've sprung that on you right at the end as well, haven't I, Stefano?
Great question. There's a huge range of different resources depending on how technically minded you are. All the regulators push out guidance. We as a firm regularly provide updates to clients on various topics. We're always ready to have a chat. We run events where we can come talk about this sort of stuff in more detail.
Amazing.
So if you're interested in hearing more about this kind of stuff, let me know, and we'll make sure we help keep you up to date.
Mate, I appreciate that as well. And I think it's even more important to trust the source of this information. So coming to someone like Sheridans to get that guidance in the first place, you're ingesting all of this information, you're up to date. It's changing so fast, you're never so sure actually of where you stand. So mate, amazing fantastic session. Thank you for sponsoring Oktoberfest. I was half joking at the beginning, but I did enjoy a beer from you. And again, from a legal firm, it's not necessarily what you expect. You're disrupting, which I absolutely love. And then in terms of today, obviously giving up the time to present, but it's also the thought and the time that's gone into the preparation. So thank you to you personally as well. How did it go from your perspective? Were you happy with everything? Have you enjoyed yourself?
Yeah, absolutely. Thank you so much for having me. Wish we had longer now. But yeah, hopefully, I'm certainly catch you and hopefully some of the people in the audience at DSF events moving forwards. And yeah, hopefully we'll be buying some more beer in the future as well.
Good man. I'll hold you to that. Even if it's just for me, Stefano, I'll hunt you down and we'll find a little corner pub or something. Amazing. Thank you to everyone for being so engaging today as well. The community, we're so lucky with the people that we have in it. So yeah, thank you for being part of today's session. Wish you all well wherever you are in the world, and look forward to seeing you all again very soon. So yeah, thanks and have a good one.